So, I mean, Mr. LeBlanc, you've done so well. I mean, better than most. You've done. So the fact that you've done all your community service, you paid your fees, you've reported like you're supposed to. Obviously, you understand that you cannot use any type of THC program, THC in any form, whether it's legal here, legal in another state. It's if you test positive, there's no way for us to know if it's legal or not legal. And so you're not supposed to use it. If it's going to show positive in a drug screen, then you can't use it. You understand?
Yes.
Ms. Malfino, Ahmad LeBlanc.
Sitting there thinking I didn't notice a nice young new probation officer.
All right, are you Ahmad LeBlanc?
Yes, ma'am.
And Mr. LeBlanc was previously in court, entered pleas of true to counts 1, 2, and 3 in a motion to adjudicate and on probation for possession of a controlled substance, first degree felony. Hold on, that's not right. On probation for aggravated assault. New allegation is a possession of a controlled substance in Chambers County. And I've received the updated report. It was unagreed. Have you both had an opportunity to review the report?
Defense has none.
Have your,
Any additions or corrections to the report?
None from defense.
only any additional that Ms. Shagwell may have from the probation department, Your Honor.
And is this the one I believe Chambers County rejected the charge.
January 28th, Your Honor.
Okay.
Or refused it.
And so, Mr. Lane, you may proceed with argument.
Your Honor, we are asking the court to continue Mr. LeBlanc on probation. He's been in jail in this last time for about 58 days. He did test positive because he had smoked marijuana before he surrendered. He lives with his mother in Baytown. He has no children. He is working at Palmer Distributing, has been employed there for a while and working a forklift. He does do online classes with Southern New Hampshire University for computer training. He does 3D modeling, and that's when he was using with the THCA that he actually got, I think, out of California online that he had sent to him. He's done his community service hours. I think he's done 433 out of 400. I believe he's paid all of his fees. This was his only hiccup. He reported his arrest, I think, the next day after his arrest. And then when the warrant came out, which was, I think, January the 20th, he hired me and then surrendered to the court. Your Honor, his mother is here. She's very, very much supportive of him, and I don't believe he'll use any more THC products. We are asking that the court, there is another plan to extend him for a year, drop program and another drug assessment, and we would ask that the court follow that alternative.
Ms. Malfino?
Judge, obviously the underlying offense involving a weapon is concerning. However, it looked like it was an issue amongst individuals who knew one another, probably involving some young women as well. Mr. LeBlanc does not have any criminal history. I hate to see him have felony, but he's also exposed to quite a bit on a revocation of this probation. I would defer to whatever Ms. Shagwell has to add, but I would ask that if he's continued, Judge, that he be extended and possibly have something a little bit more intensive than just the drop program.
Anything to add that's not in that updated report from probation?
I mean,
So, I mean, Mr. LeBlanc, you've done so well. I mean, better than most. You've done. So the fact that you've done all your community service, you paid your fees, you've reported like you're supposed to. Obviously, you understand that you cannot use any type of THC program, THC in any form, whether it's legal here, legal in another state. It's if you test positive, there's no way for us to know if it's legal or not legal. And so you're not supposed to use it. If it's going to show positive in a drug screen, then you can't use it. You understand?
Yes, ma'am.
All right. So what I'm going to do is find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find this counts true, find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. I think you've come a long way, you're almost at the end of your probation. I'm going to continue you. I'm going to extend you for 1 year. Conditions are going to be that you'll be on the high, and I don't know if he'll still be in Harris County. And so whatever they have that's comparable to what I'm ordering is what you're going to have to do. You're going to be on the high medium caseload. You'll be, you'll be required to enroll in and pay for it and successfully complete the Texas Drug Education offender program. You'll obviously have to test negative. There's going to be a new substance abuse assessment done. If there's any issues that they find that you need more treatment than what we've already saying, then you'll be required to comply with whatever that is. Do you understand?
Yes, ma'am.
Okay. So this wasn't an agreement, so you do have some rights to appeal. You can talk to Mr. Lane about that, and I need you guys to sign this, Mr. Lane, please. But you'll be released, and first thing you do is go to probation and make sure you get everything taken care of like you're supposed to, okay?
Yes, ma'am.
All right, good luck to you, sir.
Thank-
Mr. Wiskowski, in cause number 21-37917, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 3rd of 2022 for the offense of evading detention with a motor vehicle. And that was a 5-year deferred probation. Is that correct?
Yes, ma'am.
The motion alleges that you violated your probation. Count 1 alleges that you committed the offense of possession of a controlled substance February 16th of 2022 in Hardin County, Texas. And is that true or not true?
True.
Count 2 alleges that you committed the offense of possession of a controlled substance on February 16th, 2022 in Hardin County, Texas. And is that true or not true?
True.
Count 3 alleges that you provided a urine sample on March 29th of 2022 that tested positive for methamphetamines, amphetamines, and benzodiazepine. And is that true or not true?
True.
Count 4 alleges that you provided a urine sample April 14th of 2022 that tested positive for methamphetamines and benzodiazepine. Is that true or not true?
True.
And then count 5 alleges that you were behind in your court assessed fees as of April 13th of 2022 in the amount of $315. And is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 5 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before, excuse me, before you signed these, did you go over them with Mr. Crocker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection, states one.
It's admitted. Is there any evidence that Mr. Litzkowski is not competent?
None, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. And at this time, also find sufficient evidence to find you guilty. And at this time, find you guilty of evading detention with a motor vehicle. Sentence you in accordance with your agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows that this was an agreement that I followed. And so you have waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Crocker.
All right.
All right, good luck to you, sir. You can go back to the bailiff. Thank you for being
Thank
here.
you, Mr. Smith. Yes, sir.
Good morning. Are you Heyman Brandon?
Yes, ma'am.
And this is 21-36605. And it looks like number one, Mr. Brandon is charged with first-degree felony offense of murder, and Dr. Rapon was requested to do a competency evaluation. I don't know that we've been back since then. We received that report February 12th.
What,
Over here, February 24th.
All right, so I've already made that
Found him
finding.
competent.
All right, so what's the announcement?
The announcement, Your Honor, is I'm respectfully requesting one more continuance. What I think after talking with the state is that we may eventually, at the next setting, request a bench trial. And we're moving into an insanity. I need an insanity evaluation at the time of the offense. So I've got with Dr. Rapon. I'm supposed to meet with him. I
Okay,
just need a little time to get that. The state, after I get that, then we'll move forward and
okay.
yeah.
Do you think he can get that done in 30 days? He's already done the competency. I would
Well,
think he would be able to.
When he came back from the state hospital, when he was deemed competent, I called Dr. Rapon. Dr. Rapon kind of jumped the gun a little bit and thought I was talking about a competency. I already got a competency from went
Right.
out and did a competency
Right,
and then billed me. But then so I was like, it's like, hang on a second. So-
Okay.
So he's making an appointment with me. So I anticipate next couple of weeks I'll be to him and he'll maybe.
we'll do 30 days, and if you don't have that back, let us know right before that court date, and we can reset it without you guys having to come here if he's in the middle of getting that report ready.
Yes, ma'am.
Okay, all right, you can go back with the bailiff, Mr. Brandon.
Right now.
Good morning, are you Daryl Burnworth?
Yes, ma'am.
Burnworth, and this is cause number 26 DCCR 0038. Mr. Burnworth is charged with theft of property, and that looks like it was titled a first degree felony, but it was amended for the value to be of $30,000 or more, not
Right.
300,000. Is that
Right.
correct?
That's correct.
What level offense does that make it?
That makes it a third degree.
Okay. Then with everyone's permission, I'm going to make that notation on the indictment. I didn't when I amended it, but that way it won't be confusing when anybody looks at it. So I'm going to take care of that. All right. So third degree felony offense of theft of property. So what is the announcement?
Judge, I have been talking with Mr. Burnworth, and there are some questions that he brought to me in regards to his criminal history that went to the offer that was made by Miss French at this time. All his history is in Louisiana, so I just need to verify some things for her.
Okay.
So if I just get a couple of weeks, I think we'll be able to get this one resolved.
Okay. Any issues, Ms. French?
None at all, Your Honor.
All right. We'll reset it either 2 or 3 weeks, depending on the dockets. All right. You can go back with the bailiff.